Commonwealth versus Parra.
Thank you.
Mr. Camilio? Camilio?
Camilio, thank you, Your Honor. Madam Chief Justice, members of the Court, may it please the Court, my name is A.J. Camilio on behalf of the Commonwealth. Your Honors, the Commonwealth is here today asking you to reverse the decision of the Superior Court dismissing the Commonwealth's sexually dangerous persons petition against Daniel Parra. The main case that is involved here of this Court is Commonwealth versus Kennedy. Both the Commonwealth, the respondent, and the Superior Court relied heavily on Kennedy in its arguments and ultimately the decision made by the Superior Court in this case.
Kennedy, and correct me if I'm wrong, but the situation was the 60 days, I think, were violated by only, what was it, 8 days?
No, in Kennedy it was 15 months, Your Honor.
It was 15 months.
Yes. In Kennedy, what happened, Your Honor, was that the judge found probable cause, and 13 months later, everybody realized that the treatment center had never been notified of the finding of probable cause, so that the qualified examiners had never been ordered to do the examination of the respondent. After that 13 months, the judge realized it, called everybody in, and made a second order that the treatment center be notified. The treatment center wasn't notified for another 2 months. So essentially, there was a 15-month delay with 2 failures to notify the treatment center. I think the case that you may be thinking of was Commonwealth versus Gannon.
Oh, yeah, that's the one.
Where there was an 8-day delay beyond the 45 days in the qualified examiner's reports going to the court.
Okay.
I take it that what the Commonwealth is suggesting is the appropriate release in circumstances like this, because there's no violation of a court order as there was, I think, in Kennedy, was release the person. In other words, the liberty interest of keeping the person confined is taken care of, and then let the Commonwealth proceed with the hearing, correct?
That's correct, Your Honor.
Was that argued to the judge below?
It was, Your Honor. There was actually one of the interesting things about this case was that the judge below actually originally denied the respondent's motion, and then upon reconsideration allowed the motion to dismiss. And originally in her first decision denying the motion to dismiss, the judge found that there was a violation of the respondent's liberty interest in that he was held for almost 3 months in excess of the time allowed by the statute, but that infringement was not so significant that the case need be dismissed. She declined to accept the Commonwealth's recommendation that the respondent be released pending the trial in that case. She found that she was constrained by Commonwealth versus Knapp, wherein this court ruled that post-probable cause, essentially an SDP respondent cannot be released, that the statute does not allow it. In that case, the Commonwealth had opposed the release of the respondent.
The Knapp cases, as I recall, we read the two things provision together, which is once you have probable cause, then the release becomes a safety issue. Then you have to proceed lickety-split in accordance with the statute, correct?
I think that that's a fair reading of
Here, there's nothing on its face that would say to a judge, if you release the person, you're doing so in the face of probable cause that this is a sexually dangerous person.
No, probable cause has been found in this case.
Probable
Probable cause is found in this case. The difference is that Knapp assumed that the deadlines would be met, and your position here is, well, if the deadlines aren't met, then the remedy should be release, so that the liberty interest of the respondent should be protected here, not dismissal.
That's correct, Judge.
But my problem with that, I mean, you make that argument, and that's very persuasive in a way, because it is the liberty interest which is at issue, and once the person is no longer detained, then that issue, to a certain extent, disappears. And yet you took that position, but then sought to keep him at the treatment center while this appeal was pending, even though your position is he should have been released.
Yes, Your Honor.
It's very strange.
It's a mistake on our part, and we should have, and today I would agree that if the court takes a case under consideration for whatever period of time, I think that maybe the best thing to do would be to remand the case, at least in part, to the Superior Court for terms of release for Mr. Parra.
Are you in effect asking us to read the deadlines as directory then?
I'm sorry, Your Honor?
Are you asking us in effect to read the deadlines in the statute as directory?
Not mandatory.
Not mandatory, not jurisdictional?
No, I don't think that they're jurisdictional, Your Honor. I think that what we're asking the court to do is to recognize that sometimes people make mistakes, and that the overwhelming interest of the people of the Commonwealth in seeing these cases prosecuted or completed, to take it to trial, in some cases should be read in conjunction with these deadlines, and that when they're missed by some period that is not excessive, that remedies can be crafted so that the liberty interests of the respondents are not ignored, but that the overwhelming interest that the Commonwealth has in seeing these cases to completion is followed up.
Would we be usurping the legislature's function, though, then, in crafting these remedies that the legislature didn't see fit to put in the statute?
I don't think you would be usurping the legislature's prerogatives. I think what you would be doing is fulfilling the mandate of the statute, which is to see that these cases are actually prosecuted, that they're actually completed, they're taken to trial, and that the people who do pose a danger of sexual recidivism to members of the community are taken off the streets, that they're treated.
Isn't the same true, though, for speedy trial? I mean, it seems to me that one of the purposes underlying the very clear deadlines that the legislature has given is to say there are liberty interests, the most severe of which are incarceration, but obviously everybody has an interest, including the defendants, including the the people who are about to be released, and getting this thing resolved in a speedy kind of way. And the Commonwealth, I don't think, is in here claiming it's not possible to meet these deadlines. The Commonwealth is in here claiming it was a mistake. And the difficulty, I think, is the legislature didn't say do this within a reasonable period of time.
I think that's true, Your Honor. And that's why we referenced the DeBella case and the Gannon case in our brief. In both of those cases, the main distinction, and I'm sure that the defendant will point this out to you as well, is that the liberty interests were not nearly as great.
But in Gagnon, there was no deprivation of the defendant's liberty interests, none.
I agree, Your Honor. But the point being that there was a missed deadline. So is the question, I guess the question then becomes, is it the deadlines that are important, or is it the liberty interests?
But was it an intermediate deadline in Gagnon?
Well, it would depend on
Did the Commonwealth file a timely trial petition in that
Yes.
case? Now, in Kennedy, did the Commonwealth file a timely trial petition?
No.
Well, here, the Commonwealth filed a timely trial petition, but then withdrew it.
Well, it was not timely when it was filed. The judge found probable cause on July 13th. We filed the trial petition on September 22nd. So even
And it was due when? It would have been due if the reports had been filed within 60 days. It would have been due on September 26th.
September 3rd.
September 13th.
Oh, September. Okay, I'm sorry. So it was late.
It was late. And it was filed because at that point there was a realization that there was no qualified examiner reports, which should have been due 45 days after July 13th. And that would have triggered the...
Can you envision a situation where the delay is so long that a judge would be supported in dismissing the case altogether?
I can, Your Honor. And I think Kennedy sets out that time frame. That was a 15-month delay, which
So 3 months is okay.
Under these circumstances, 3 months was okay. The reason that...
Let me ask the question slightly differently. What's our standard of review here? Is it abuse of discretion? If you're saying that, in answer to Justice Ireland, that, it's reasonable in a case-by-case determination, you have the judge here dismissing. Aren't we looking at an abuse of discretion?
I don't think so in this case, Your Honor, because if you look at the judge's two opinions that were filed in the Superior Court, the first opinion, which denied the defendant's motion to dismiss, the judge recognizes that she was not required to dismiss under the holding of Kennedy.
Then she gets Knapp and she says, I'm required, correct?
Yes. If you read the second...
Is there a relief in those circumstances to send, if we were to agree with you that it is permissible to go outside, to send it back and say...
I think that might be a possibility, Your Honor, that if you do read the judge's second opinion as her essentially saying that I don't have the discretion to craft a remedy here, that the only thing that I can do is that she was constrained by the holding in Kennedy that she had to dismiss the case because of the delay. I think that it would be reasonable to remand it to the Superior Court for further findings and for the judge to exercise her discretion. I
know that the facts in Knapp are different, but there's very strong language in Knapp, which you both are looking at Knapp, but to the effect that after finding of probable cause, the statute operates to deprive the judge of discretion with respect to whether the person will be committed. I mean, what's the basis for revisiting that?
Well, two things, Your Honor. First of all, in Knapp, the Commonwealth did not agree with the judge's decision releasing the defendant after probable cause, and that was not the main point that this Court made in its holding in Knapp, but it is a distinction. And secondly, here the defendant would be...
The language that I've just quoted doesn't go to that issue. It just says the legislature has set it up, the legislature has balanced this, the legislature has laid out a timetable. Nobody's claiming that the timetable cannot be met unless, as with the Speedy Trial Act or anything like that, the parties can agree, your expert's not ready, my expert's not ready. I'm not sure that you can do that, but it appears that you can do that.
I think you can do that. I think that the other distinction here with Knapp is that here, in releasing the defendant, you would actually be fulfilling the main reason for the statute itself. You would be allowing the Commonwealth to take the case to trial. You would be allowing the Commonwealth to see that the legislature's desire that persons who may be sexually dangerous are tried is done. In Knapp, that was...
But the same reasoning would hold for example, the speedy trial laws that have been enacted, which is that the Commonwealth, the state, has a very real interest in prosecuting crimes, people charged with crimes, but it recognizes that they're countervailing interests, and those liberty interests are not limited to incarceration. They encompass a variety of other interests of defendants or,
I think one of the distinctions between the speedy trial rules in this case is that the speedy trial rules are much more liberal in their application. But
there's been no claim here in any of these cases that the Commonwealth couldn't meet it. It's been a mistake, an accident, an overlooking. And I think that we've stayed pretty close to saying this is what the legislature wanted, and these are deadlines that can be met. I don't know what agreements can be worked out, between counsel. Those are permissible, but if they can't be worked out, then the Commonwealth has to proceed within a particular deadline.
This wasn't a case where any agreement could have been worked out. This was just a case where because the qualified exemption...
If this goes back to Judge Fahey, are you saying the Commonwealth would agree to release this man?
Under conditions, yes, Judge.
Oh, you've looked at the situation and you feel he is not that much of a risk, that this could be done?
We feel that he's a grave risk, Your Honor, but we feel that it's better to release him temporarily pending a trial where he could be then recommitted for a day to life than to...
So what if we have another case where the district attorney office says, we've got this remedy of conditional release, we've missed this deadline, but this guy we just can't agree should be released. And the judge says, I agree with you, he's a walking time bomb. So now what are we going to have? Two classes of defendants where deadlines have been missed? One might get released, the other will not?
I think that's the reason we have judges sitting in the Superior Court who can hear the facts of each case. That
Isn't that the reason why
That's
we
the
have
reason
the
we have the
legislature
deadlines.
who set the deadlines? And as I say, there's been no claim that it wasn't possible. We had a case just yesterday which requires cases to be brought to trial, at least one interpretation of the statute within 60 days or something, and everybody conceded that's not likely, maybe not even possible. Here, as far as I can understand it, this is a case where something slips between the cracks. Somebody's not watching the dates, and somebody remains incarcerated.
that's a fair assessment of the case, Your Honor. But
Is there any limit on the amount of time that an agreement can be struck for letting the defendant out? I mean, could it be a year while they, when things start getting busy? So I thought the legislature wanted these cases to be tried and the defendants held until the trial takes place, and that's why they set up this rigid schedule.
they do, and that is why they set up the schedule. But the alternative here is to have no trial, to have no way to determine Mr. Parra's...
The alternative here is to have somebody with conditions, correct? So that's an invasion of his liberty interests or her liberty interests. I take it that the conditions are going to be quite severe, correct?
They would be whatever the judge would
Well, I
impose,
understand,
but
I
we
think
would
the
obviously
Commonwealth,
request...
if your representation, which I take is correct, is that the Commonwealth views this as a dangerous person, that the conditions will be quite severe, regular reporting, maybe daily reporting, a bracelet, whatever it is.
Those would be our requests.
Yes. And for, it's already been quite a long period of time.
It's been almost three years.
Now, can the defendant demand a speedy trial and avoid being released?
Well,
I take it at this point you're ready for trial.
Yes.
Presumably.
Yes.
You've now got all of your ducks in a row. It ended up taking a lot longer than the statute provides. And
Yeah, the case could have been tried last year. That's when it was ready for trial last December 3rd when we filed the petition for trial. But at that point, the defendant filed his motion to dismiss, and that's why the case has been delayed for an extra 10 or 11 months.
Thank you, Mr. Cornelia. Mr. Hirsch?
Thank you. Please, the Court. David Hirsch, representing Mr. Parra. Justice Cordy mentioned the possibility of creating two classes of persons detained as SDPs or persons alleged to be SDPs were we to follow the Commonwealth's suggestions in this case. I would suggest that there would be at least three classes. And that's because any time you set up strict conditions of relief, you have to have a mechanism by which the defendant can meet those conditions. Say the first one would be housing. How many people at the at the treatment center could meet any particular requirements of housing set by a trial judge? Now, when the legislature established this law, they did not establish any less restrictive alternative provisions. They did not establish housing for possibly sexually dangerous persons.
Well, that was Judge Cowan's point, that we would be in effect rewriting the statute where they have spoken, at least we said so in the Kennedy case, clearly. They have said, said it out clearly.
I agree with you.
Now, these deadlines, then, would you take them to be in the nature of statutes of limitation, where counsel could agree to waive them? We've talked about that. That wasn't done here, or extend them. But if not met, out?
I would argue that they should be statutes of limitation, but I don't think the Court needs to decide that issue to decide this case. In other words, say...
No, I'm
one
not,
is, I think, just...
I'm not saying they are. I'm saying they're in the nature of.
I take it the import of the question is whether or not it's possible for the parties to agree to waive them as opposed to, are they jurisdictional bars?
I would say, I would argue they are jurisdictional. I can also see a situation in which the Court might find an exception to that rule. Say, if I were to tell, if we were litigating this case and I were to tell my brother, oh, don't worry about the 60 days. I just want you to do a really, really thorough job, have those QEs do a little more, let's take a little more time, I can understand.
That won't cut the mustard if it's jurisdictional. It would cut the mustard if it's a limitation.
I understand.
So
And
it's kind of important what kind of label we put on these things.
I understand, and that's
Keeping in
why...
mind, I guess we're dealing with proceedings that are not purely criminal nor purely civil, correct?
I agree. And that's why I gave, Your Honor, the answer that I did, that
Okay.
we don't need to decide that issue right here
No, we don't.
in order to come to a valid conclusion.
Can we decide this case the way you want it, simply by relying on Kennedy, where we say the word "shall" in this context, where substantive rights are involved, indicates that the action is mandatory? This imperative is at its strongest in such cases, and on and on?
Absolutely.
That would end the matter.
Absolutely, and that provides the clearest distinction between this case and something like Gagnon, where there was no deprivation of liberty, and therefore the imperative of the word mandatory is much less.
Well, in Kennedy, we did hold out the prospect of concluding that something less than dismissal might be appropriate for deprivations of liberty that were not as extreme.
Yes, but first of all, I think if I have one disagreement with the language of Kennedy, it's discussing a lesser sanction. We're not talking about a sanction here. We're not talking about punishing the Commonwealth for wrongdoing. What we're talking about is upholding the basic due process rights of the person involved.
Well, we'll call it a remedy.
Okay. I think we're in much better shape then, and I think we're...
We said that the remedy of dismissal might not necessarily be required for lesser deprivations.
Well, again, the Court did say might, and assuming that the Court might, I would like to point out why that might would not apply in a case like this one, why such possible discretion on the part of the Court could not be used in a case like this.
Well, if a hurricane struck, for instance, and prevented a trial or prevented the Commonwealth from filing its petition in a timely manner, that might constitute a...
Exactly. Or if the QE had a heart attack and they couldn't find another one with, say, the 2 weeks remaining. But here, we have a situation where the Commonwealth had the benefit of the Kennedy case, the Gagnon case, the DeBella case. They knew what their obligations were. They knew what happens when the QE reports and the trial petition aren't filed on time. Now, nothing here prevented the district attorney from calling the treatment center saying, what's going on in the Parra case? Just want to make sure that this 45-day limit isn't being violated. After the 45-day limit, even after that passed, it appears nobody from our record, it appears that nobody from the DA's office called MTC and said, what's going on here? Even after the 60-day period.
Mr. Hirsch, your brief is replete with the suggestion that there was no abuse of discretion, correct?
Correct.
And my understanding of the judge's second order is that she concluded that she had no alternative, correct?
Correct.
And your brief seems to suggest that she did have an alternative, it just wasn't an abuse of discretion. I know it's the second part of your argument, but that's how you have to deal with Gagnon and...
I think that's a backup argument on my part, Your Honor, should this Court decide that the lower court did have discretion. I do not think the lower court did have that discretion.
Okay. If we conclude that a trial judge in these circumstances does have an abuse of discretion, what is the appropriate remedy?
That the trial court does
have discretion. Here I have a trial judge who says, I don't have discretion. But in fact, she evidenced her view that if she were exercising her discretion in the absence of NAF, she would keep him detained, correct?
I would say that under that situation, this Court has the obligation to determine whether that hypothetical issued by Judge Fahey is supportable. And I don't think it is, for the reasons I've addressed in my brief and that I'm addressing right now.
I take it what you're saying is that if we sent it back and if she decided that this particular person should not be released, as a matter of law, that would then constitute an abuse of discretion.
Yes.
Okay.
And I think in order, there's been such a violation of Mr. Parra's rights in this case. The period during which he was held after the 60 days, the period between Judge Fahey's two rulings, the period between the second ruling and today. Now, my brother says that, yes, we should have asked for release. That doesn't help Mr. Parra. We know that a release is, that a stay of proceedings is a legal fiction saying that time stops, but time doesn't listen to us. He has spent so many...
Is there any reason why you couldn't have moved without waiving your right to say it should be dismissed, but for his immediate release?
You did, didn't you? Didn't you move for his release?
You did, and it was stayed by the appeals court.
Yes, and I also moved to strike the stay, and that was denied.
So if we accept the district attorney's recommendation about creating this alternative remedy in these cases where they make these kinds of errors, it would have to apply across the board. The judges would be told you have no discretion to retain anyone. If the Commonwealth has missed a critical deadline, he, or most likely he, has got to be released on conditions, and you've got to find some conditions that will do it. And they've got to be conditions that will get them released. So
I think that's correct, and I think, as several of Your Honors have pointed out...
So your idea, not your idea, but your suggestion, which I tend to agree with, that these folks won't have any housing, nor likely to get it, would be inapplicable. The judge would have to release them, housing or no housing.
Well, I think if there were going to be any fairness to the Commonwealth's suggestion, that's the truth. And again, that's one more step of rewriting the statute that I don't think this Court is enabled to do.
Well, the statute doesn't provide a remedy. It doesn't say that a violation of any of these deadlines shall result in the dismissal of the petition.
But this Court's
said in Kennedy, with a 15-month deprivation of liberty, that a dismissal was an appropriate remedy, and in a lesser case, perhaps some other remedy.
I don't think that's an entirely correct reading of Kennedy, because Kennedy starts out by telling us, because we conclude that there has been a violation of the clear and unambiguous statutory language requiring, A, that a defendant in a GLC 123A case be committed for an initial period not exceeding 60 days, and that, B, that the reports of examination and diagnosis be filed within 45 days. For those reasons, the Court upheld the dismissal of the case. If a person cannot be committed for more than 60 days prior to the trial petition, then he can't, then that commitment has to stop after 60 days. And as one of Your Honors pointed out, even if he's released to some kind of very strict conditions, he's still under commitment. He's still deprived of his liberty. It's much like the Bolero case.
Following up on the last question, do you think the legislature ever contemplated that some of these folks who are subject to, in this case, two qualified examiners saying they're highly dangerous, would ever get outright released without an adjudication by a judge or a jury or both?
If I had the power, Your Honor, I would ask this Court to reconsider the Knapp decision and consider such things. But that's not my power, and I have to live with Knapp.
You mean the import of the Knapp decision that says they have to remain incarcerated?
Yes.
If they have to remain incarcerated, then you have to move promptly.
Yes. Have to means have to.
Shall means shall in this case.
It's just as if, say, my brother and I were litigating a serious felony case. We came to a plea bargain saying, despite the 5-year mandatory minimum, we're going to agree that he's going to plead to the crime charge, but ask for a 1-year sentence. The Court can't do it, even though we've agreed. Our agreement doesn't change the law. The law is the law, and shall means shall.
Well, that's why that's why, you know, are these jurisdictional limits, or are they statute of limitations and so on and so forth?
I mean, in Knapp, what we said was that after a finding of probable cause, where the statute says that the person shall be held in a secure facility pending the trial,
Right.
that means what it says.
But the court in Knapp also said that the ability to hold somebody beyond 60 days requires both the probable cause finding and the
Petition.
excuse me?
And the what?
And the two qualified examiners' reports. Here, we did not have the two qualified examiners' reports. That, the court concluded, this court concluded, was necessary to prevent incorrect, wrongful confinement of somebody who really wasn't even likely to be sexually dangerous. So when we don't have that, you can't hold them. This may be the first time in a 27-year legal career when I don't use up all of my minutes.
We applaud you, Mr. Hirsch.
Thank you, Your Honor.
We allow you to bank them.
No, we do not.
I thought it was like one of those pollution trading laws, Your Honor. I'll conclude that there can't be an inconsequential error where the error takes longer than the actual statutory time limit. There's a 60-day limit, and my brother has just said that an 84-day delay beyond the 60-day limit is not consequential enough to require dismissal. I think all of this court's case law on the subject say otherwise. I don't think there's anything about Kennedy that says that the deprivation has to be outrageous and beyond our capacity to envision in order for the mandatory provisions of the statute to kick in.
Thank you, Mr. Hirsch. We'll take a short break.
All right.